Thank you very much. It's indeed an honor to be here at this event and also to share a panel with such distinguished colleagues here. So we'll straight away get into the discussion, before which I will introduce our panelists. As was mentioned, one of our panelists, Ms. Sarah Barker, is unable to be here. She actually arrived in Singapore about a day ago, and she took a rapid antigen test last evening, and it was the, what we've all been fearing for the last 4 or 5 years. So unfortunately, we will miss her immensely. But I'll anyway go ahead and introduce Sarah, though she's not here, because she's been such an influence on the topic that we've been talking about, which is on directors' duties and climate risk. In fact, Sarah is managing director at Pollination Law, and before that, she was a partner at Minter Ellison. And the reason why I'm going to mention Sarah a little bit more is because she was instrumental in developing this idea of obtaining legal opinions to educate directors of corporate boards on climate risk. And the first opinion was obtained at the instruction of Sarah from a barrister known as Noel Hutley. So there's been a series of opinions emanating from Australia, which then spread to many other countries around the world. So the idea has been to educate directors of their duties on climate risk, and this panel is nothing but one such effort as well. So we will miss Sarah, but we'll continue with the panel as such. So to my left is Mr. Shyam Dewan, who I'm pleased to introduce. Mr. Dewan is a senior advocate at the Supreme Court of India and is a highly sought after legal counsel in India. And among other things, he is also a prolific author, including books on and chapters on environmental law. And he's co-authored one of India's leading environmental law books. And I must admit, I haven't mentioned this to you specifically, but when I was an undergraduate student of law in India, I studied environmental law from your book. So, and most recently, he was also elected as the president of Law Asia in November 2023, so he holds that responsibility as well. So, and incidentally, Mr. Dewan also has had the opportunity to issue the Commonwealth Climate Law and Initiative legal opinion on India, so he's the best person to speak about it. And India was mentioned by Justice Philip Jeyaretnam, so I'm going to probe a little bit more with him on some of the issues that came about. Then to his left, we have Mr. Michael Tang, who's the head of listing policy and product admission, and more importantly, for our purposes, head of Sustainable Development Office at SGX Redco. So he leads the listing policy for SGX Redco, and more importantly, he champions efforts to imbue sustainability through the investment value chain. And one of the aspects that we've seen is the important role that SGX has played, especially on the element of disclosure, where they've taken a lot of pioneering steps which have received a lot of recognition around the world. So it'd be an honor to speak to Michael and get his views on that. And finally, we get to where the rubber meets the road, which is the person who has to implement everything that is being discussed on the panel. And I'm very pleased to invite Ms. Tina Mavraki to this conference. She's a portfolio non-executive board director and strategic advisor with a lot of ESG experience. So she's the one who actually operationalizes everything that we're going to discuss here. And she's also a thought leader in the space. She's worked with the UK regulator, the Financial Conduct Authority's ESG team, and has been involved in a lot of law reform efforts in the UK. And it would be nice to hear from her, both on the law reform experience in the UK, as well as your experience sitting on the boards of various companies. So we have quite a diverse panel here, and there's a lot to discuss. And judging by the nature of the audience, I'm sure there will be a lot of questions. So we will have sufficient time. I will be sure to allocate a lot of time. So please do keep a lot of questions in hand for the panelists as we move along. So let me, before I hand over to my co-panelists, let me set a few thoughts and set some basic ground aspects that we already know about the topic that we're going to talk about. So the first thing as a given today is climate change as a corporate matter is not something about merely about ethics. It's also about, or voluntarism. It's about material financial risk to companies. And yesterday we also saw a reference to Mark Carney's report, Tragedy of the Horizons, where he also refers to it as a systemic risk. So now the focus on directors' duties is not so much as an ethical consideration only, but it's also about systemic financial risk and material financial risk to companies for which directors have to be responsible. And corporate boards can only ignore this risk at their own peril because they could be subject to actions and liabilities. There are limitations to that, but we'll talk about it. The second thing is there are varied approaches to directors' duties around the world. And interestingly, we have a panel with quite a bit of diversity, so we can talk about different approaches in different countries around the world. Generally, the duties are divided into the duty of loyalty and duty of care, skill, and diligence, but different approaches, different countries have approached it differently. So if we take the UK, we have section 172 of the Companies Act, which adopts what is called as the enlightened shareholder value approach. So there's a reference to environment and community in the act itself, but it has a certain type of meaning. And then we have India, which also has a reference to the environment, but it adopts what is known as a pluralistic approach. And we'll talk a little bit more about that as we get along. And the third example is for Singapore, for instance, which on the face of it at least looks shareholder primacy oriented because there's no reference to the community or the environment at all in directors' duties, but that does not mean that directors are not allowed to or even not required to consider the issues pertaining to the environment. So we have different kind of approaches, and we can try to make sense of a lot of this as we go along. And a few other things which are a given in most of the jurisdictions that we're going to talk about, which complicates issues of enforcement, is directors owe these duties to the company and not necessarily to either shareholders or to the other stakeholders. So this might lead to issues relating to enforcement. And I know Jolene is going to moderate a very exciting panel that we're all looking forward to on corporate litigation. And I think our discussion on enforcement will probably border a little bit on that, but we'll touch upon it in the context of directors' duties. And the last part, which I'll mention before I kind of raise the questions, is there's a difference between law in the books and law in action. And this is more so when we consider the issue of climate risk, because there are two important changes that are happening around the world. One is the science relating to climate risk is expanding, and our knowledge about climate risk is expanding very significantly. So it's not just about the director's duties that are enunciated in the statute, it's about how you interpret those statutory requirements in the context of developments in the scientific field. And the second is the context matters. Awareness, and Justice Jayaratnam talked about awareness, and he talked about the risks of misinformation or disinformation. But the greater awareness we have on climate risk, the nature of directors' duties also acquires a sense of dynamism. So things change over a period of time. And I want to end my initial remarks with a quote by Lord Sales a few years ago, where he kind of made this important point that the effect of directors' legal obligations cannot be understood simply by referring to the bald statement of them in the relevant legislation. An assessment of the practical implications of those duties has to take into account the general environment of expectation created by initiatives by the regulators and civil society. So how regulators think about it, how investors think about it, how civil society thinks about it will all shape the nature, extent, and scope of directors' duties at the end of the day. So some of these issues are kind of a given. This is a context in which we are living in the current legal atmosphere. And I think with this background, we'll delve a little deeper. into some of the more specific aspects that I'd like to probe with the panelists. So maybe I'll start with Mr. Shyam Devan as the lawyer in the panel. So a couple of things I wanted to ask you, and please feel free to share the experience relating to India, because as Mr. Judge Jayaratnam mentioned, I think there are important learnings in the Indian context, but you can also kind of compare with other jurisdictions as well. And a couple of things to think about is how do you think of the directors being fiduciaries in the context of climate risk? So what is their role as fiduciaries? Who are they fiduciaries to? And I think this is more important in the context of India than other jurisdictions, because in India, corporate law is not based purely upon a shareholder primacy approach, but the concept of public interest is infused into the whole analysis. So how do we think of directors as fiduciaries in the context of climate risk, the way it stands today?
Thank you very much, Umakant, and good morning to all of you, and thank you for this opportunity to being part of this panel. Let me just broadly set out the 3 or 4. I liked what Professor Megan Bowman mentioned yesterday. She used the word trident. So we have a bit of a trident approach in India as well, a regulatory approach. And there are 3 essential prongs to it. So let me set them out and then come to fiduciary duty right away. The first prong is we use the Companies Act, which is essentially the statute which governs everything from the birth till the death or the liquidation of a company. So that's one basket under which we move to regulate insofar as climate is concerned. The second prong is and I thought this was sort of a little unusual in the India context, but I noticed that Singapore has done it as well, and perhaps several other jurisdictions. But the second area is essentially the financial market regulator. So in India, the financial market regulator is called the capital market regulator, is called SEBI, the Securities Exchange Board of India. So that's the second prong. And the third prong is as of 15th October, just a few days ago, when you had a set of regulations or guidelines which were framed by the consumer industry. And that's on the greenwashing point. But so you have these essential 3 prongs, and supplementing this regulatory regime is the role which is played by Indian courts and tribunals, which tends to be a little more than in most other jurisdictions. And I'll just touch on that as well. So coming to the Companies Act and the specific question on fiduciary duties, we have a relatively new Companies Act of 2013. And the 2013 Act, in this respect, which is with respect to the obligations and duties of directors, is a departure and an expansion of the previous law that we had. So we have a provision, section 166, subsection 2, and essentially what it says is that directors, all directors, are required to act in good faith to promote the objects, the purpose of the company, and then it goes into 3 subcategories. The first category is the traditional notion of a fiduciary, which includes you've got to act in the best interest of the company, which would certainly include shareholders and employees, for example, and the objects of the company. That I would describe as the traditional approach. But then it goes further, and it obliges directors to also be conscious of the interest of the community. So that's a specific expression which is used in 166.2 along with the company. So first you have company, then you have the community, and the third expression which it uses is protection of the environment. So that's there in terms of black letter law. And it has been described as a triple bottom line test in the sense we have these three categories under which you have to ensure that the affairs of the company are conducted consistent with these three broad objectives. And as Professor Umakant rightly mentioned, he described it as, and in his writing as well, he refers to it as a pluralist approach, which is you don't have just one master, but you have at least three value systems here which you have to be conscious of. There's no specific ranking yet within them, but I think it's a question of ensuring that all three are broadly met in the discharge of your duties. Now, within the board of directors, speaking about fiduciary, there's a subcategory. And we have a notion of independent directors. And there's an express obligation on independent directors. So those are not employee directors, but independent directors. And they are required to be informed about, and then the statute uses the word external environment. And I think here the external environment means all external factors, whether they are market factors, financial factors, but I think it would also include aspects such as the impact on climate change, environment generally. So this is the framework, therefore, for fiduciary duties. If you fail to discharge those fiduciary duties, there are liabilities under the Companies Act. Has this been tried in the context of environment before the company tribunals? The answer is not to my knowledge, or not yet. Is there potential for using it? Possibly, but I'll just delve on that when I come to that aspect about tribunals and courts in India being a supplementary form of regulation. So that's the first basket. The second basket is the Securities Exchange Board of India Act. And when this statute came about, these regulations came about, and they've been developed since 2015. And in its latest avatar, it requires the top 1,000 companies by market capitalization to make disclosures in the form of annual reports, which go out to the public and which are uploaded, etc. And those annual reports are specific in terms of greenhouse gases, and there's minutiae over there in terms of your obligations for climate obligations. But that's a subset. There's a wider set of environmental disclosures which you have to make. So you also have disclosures in the context of energy. You also have disclosures which you have to make in the context of pollution. And you have to have disclosures, for example, in terms of plastic use, etc. And further, these disclosure requirements on the top 1,000 companies by market capitalization have now brought in, and it's in the process of discussion, also further disclosures down the value chain of the company, depending on 75% of your turnover, etc. So that's the second big bucket. And I was thinking to myself that why is the natural regulator, which is the Environment Ministry in India, not imposing these regulations? And I'm not very sure. Perhaps they've aligned it to other global norms which are taking place, concentrating on these top 1,000, the largest Indian companies by market capitalization. But then it occurred to me that had the Ministry of Environment introduced these regulations, you would probably have to look at it across the board. It would have applied to all companies. And if that were the case, then policing and enforcement might have become very, very difficult. So I think this is an interesting manner of focusing on a particular set of the biggest corporate entities, and perhaps that might just lend itself to better enforcement through this dual mechanism of fiduciary duties which are expanded, and number two, the element of requiring periodic reports. The final third prong, so to speak, in the trident is just recently issued. And these are guidelines which prevents greenwashing in the form of advertisements and claims. So you cannot make a false claim. You're advised that any claim which you do indeed make with respect to the environment has to be properly justified. And if that could be a form of or provide a cause of action in terms of approaching a suitable dispute resolution tribunal if you make that claim which is false and it is found to be deviating from these tribunals. All right, now just to sort of, I did mention that there is a third, or rather a fourth element which drives the process in India, and that is our courts and tribunals. So first, let me just share a statistic. As of this morning, because courts haven't yet started, we have a national judicial grid, which I sort of punched in this morning. And the total number of cases in India is 11,093,616. That's just the civil cases. If you add the 33 million criminal cases, the total pendency is 44,516,589 as of this morning, 60% of which are more than 1 year old. To also give you an idea of our Supreme Court, which I'll probably refer to later on in another context, the total pendency as of this morning was 82,391 cases. 33.47% were less than a year old, and last month they disposed of 5,590 cases. So the courts are extraordinarily overburdened, and you really are fighting for time to get that, to get your case listed, to draw the attention of the court. But it's, and I'll come back to that, it's clearly a manner of leveraging the system, elevating the importance of certain specific environmental issues. And I do see climate litigation being pretty high up on the agenda in the years ahead. Thank you very much.
Thank you, Vishal. So I just wanted to kind of, before I pass on to Michael and Tina, I just wanted to kind of push on one point which Justice Jayaratnam also mentioned in the morning. You have a wonderful pluralistic approach that's set out very clearly in the Companies Act itself. But there are challenges, as you yourself mentioned, about enforcement. But one roundabout method of enforcement that seems to be taking shape in India is one cannot rely on customary enforcement of directors' duties the way we think about it in other jurisdictions. It's been tried and tested, not that successfully even in the UK, in the McCoy and Client Earth cases. But it seems to me in India, the Supreme Court is likely to consider the duties of directors in the Companies Act while dealing with public law issues. So Justice Jayaratnam referred to the Great Indian Bustard case. Though it was a constitutional case, the judges made a reference to Section 166, as you've referred to in your opinion as well. So do you think when it comes to enforcement of directors' duties, there are other innovative measures that can be taken in the Indian context that may not be customary or may even be too interventionist in other jurisdictions?
Okay, how long do I have to answer this?
I think you have about 3 to 5 minutes.
Okay, so then let me just focus on the bustard, because that's an interesting case which is there. So I'll tell you what happened. The Great Indian Bustard is a bird which is the heaviest bird capable of flight anywhere on the planet. We are down to less than 100 in number. And so M.K. Ranjit Singh, who was he's a senior citizen, but he was the first, he was the top bureaucrat in the Ministry of Environment right from early days. And the Great Indian Bustard at one point of time, and Lord Cranworth knows about this, was competing to be the national bird. And then our first Prime Minister, Nehru, felt that this expression bustard was apt to be confused with certain other parts of the English vocabulary. And so we settled on the peacock. But the bustard hasn't exactly thrived. And the reason is that it has no frontal vision, and it collides with these overhead transmission lines. And so the petition before the Supreme Court was that, look, on the watch of this generation, on you, the judges' watch, we cannot afford to lose this magnificent bird in our lifetime. And so, the court got all very excited about it and said, all right, what can we do? And essentially, we got orders in the first instance which said that all overhead transmission lines, except those which technically cannot be put underground, must be placed underground over a vast swathe of land in Rajasthan and in Gujarat, which is the last remaining habitat of the great Indian bustard. So we got this order, and the progress was extremely slow. Now I'll tell you about it maybe in the second round of questions or the third round subsequently. But the public law element which you mentioned over here was the question immediately arose, how are we going to fund this? And whose duty is it to underground these overhead cables? And the answer, the court which found, it didn't specifically direct, but it found it placed it at 2 or 3 levels. First, the duties of directors, 166(2), which I mentioned. Second, we have a provision in the Companies Act in India called corporate social responsibility. And this statutory provision obliges every company which has, and it's linked to the net earnings of that company, to set apart, it's virtually a tax, on corporate social responsibility spendings. So that could be any type of development work, it could be educational work, it could be work for uplift in other areas of development, but it includes environment. So the second provision which the Supreme Court of India noticed was that, look, funding could be potentially obtained from your CSR obligations as far as companies are concerned. So you have directors, you have your CSR obligations. A third area was that in a separate case in India, when there was rapid deforestation taking place, the court imposed virtually a levy for the purposes of ensuring environmental sustainability. And those enormous funds which were collected are also available for spending in matters such as this. So those are raised from corporates, but in the past, for diverting forest lands, the funds are available. Let's use that money. So stop whining and complaining about money. That was the kind of message which the court wanted to convey. So that's the mix-up in public law. The case was essentially a public law case, but then obviously we were treading on private toes as well.
Thanks so much. If time permits, we'll come back to this a little bit. So let me move to Michael and, in a way, transition from India to Singapore. And it's very interesting to see, as an observer of corporate governance in Singapore, if you went back to 2016, even 2015, 2016, there was no mention in corporate governance or corporate law or SGX regulation about sustainability, environment. It was kind of a largely shareholder primacy approach. But 6-7 years later, Singapore has moved from one end of the spectrum to the other because these issues have come to the forefront. Corporate governance code recognizes sustainability. SGX has introduced significant disclosure requirements and so on. So there's no better person to speak to us about it than Michael, who looks at these issues from an SGX perspective. So Michael, maybe my question to you would be, when you think about SGX, public listed companies and so on, how do you see this transition from a corporate purpose point of view, from like a shareholder primacy approach to quite a bit of a focus on stakeholder primacy as well? So maybe we can start with that, and I'll have some follow-up questions as well.
Sure.
To you after that.
Thanks, Umakant. And thanks for having me here. I'm very glad to be here to share with you from my perspective what are the policy considerations that a securities market regulator would have in terms of directors' duties, corporate purpose, as well as disclosures. I think we can go into some of that as well. But maybe as a general point, I'll probably first say that I'm a policymaker, but there is definitely strong interaction between policy and law in this regard. Both work together to influence corporate actors, such as directors, shareholders, even other stakeholders, in terms of their expectation on what needs to be done, their behavior and their attitudes. So law, I think, sets a minimum standard, but I think policy represents really the norms as well as the expectations. And I think in the corporate world, it's probably best expressed as the corporate governance landscape of different laws, rules, regulations, and guidelines to dictate behavior of individual companies. And while norms and policies are informed by the law, I think an appreciation by lawyers and judges of what the policymakers are looking at would also better allow them to understand the motivations behind corporate actors in this view. And maybe then, if I can answer the question on shareholder primacy, Umakan, that you've mentioned, I think from the policymakers' perspective, there are at least maybe 4 different models or reasons for why companies and directors should look at sustainability, in particular climate risk, when they look at their corporate decisions. The first, I think, is probably the traditional model where we squarely place the obligations in terms of the interests of the company. And I think nowhere is this maybe more paradigmatic as in pollution laws, that when an enterprise or a business creates an externality, then the law steps in to internalize the externality by imposing fines or imposing injunction against this externality. And I think from the business perspective, and I think Tina will share more later, the way that we've seen it is that sustainability performance really impacts business performance. And there are probably 3 ways in which at least 3 ways in which this happens. Firstly, from the efficiency or efficient use of resources perspective. If you're using less energy, you incur less cost, and therefore your business performs better. So that's one clear-cut manner in which I think sustainability impacts business performance. Another is really from the risk management perspective, where you're looking at upcoming risks, either from risk of regulation or risk of changing consumer preferences in terms of what they want to consume, their demands for more environmentally conscious or friendly products. I think that's another angle which would impact on business performance as well, because it looks at your risks that you may not be able to continue to sell to these consumers. And I think the third is really from the opportunities perspective. And I think anecdotally there have been more consumers who are willing to pay for greener, in a general sense of the word, greener products. So that would also represent a new landscape with, I think, this focus on sustainability. There's more demand also on, say, new sources of renewable energy. That's another avenue in which maybe energy companies can tap into. So even on the traditional analysis of a company and what a business and directors should be looking out for, under this model, I think sustainability definitely impacts business performance and therefore should be taken into account. I think another model from the securities markets perspective is that we have investors who are invested in a portfolio of companies. So they're not invested singly in one company, but in even maybe a value chain of companies. And the externality created by one company will also impact the business performance of another company. And if you are an investor, a shareholder in these companies, from your shareholders' interest perspective, even considering just the financial interest, this is something that you want your portfolio companies to take into account. And a proof point for this really is the many pension funds and sovereign wealth funds out there who are universal owners because they invest in almost a representative stake of the economy and therefore has interest in ensuring that their portfolio are not adversely impacted by climate change. Now, a third perspective, also staying with shareholder primacy, is that shareholders themselves are not heterogeneous, and it is an assumption that we make that all shareholders want only financial returns. Some shareholders may be more interested in non-financial returns in the impact that their investments have on the environment, on society. And I think the proof point for this is really the rise of impact funds, which invest in companies based on their sustainability performance, as well as the rise of philanthropic capital, where they are able to accept maybe a lower rate of return in order to provide capital to catalyze some greenfield projects, which will have a good impact, but may not as yet make as much commercial sense. So I think these, even staying within the shareholder primacy perspective, are some policy reasons for why companies should take sustainability into account. Now, the fourth, I think, is really moving slightly out of shareholders to looking at other stakeholders. And again, the proof point here is in a business roundtable that's convened in the US, comprising of the world's 200 largest corporations in the world. The CEOs there have made a marked, I think, shift from shareholder primacy to saying that we need to, as corporations, also take into account stakeholder needs. Your suppliers, your customers, your employees, your communities, in addition to shareholders. And I think this marked shift is another proof point for how, from the securities law, securities policy perspective, we want companies and directors to look at sustainability. Now, if I then maybe address the question about why I think the three prongs that Mrs. Divan mentioned earlier about how and why financial markets are really involved and also leading some of these initiatives in terms of climate action. I think the setup of the task force on climate-related financial disclosures is probably the proof point for why financial markets wants to get involved. This task force was convened under the auspice of the Financial Stability Board, representing the global prudential regulators. And the worry there is, you've mentioned Mark Carney, the worry there is that if we do not collectively take action, that the business risks that I've mentioned would eventually impact on the financial markets and would have a devastating impact on financial markets. And I think that's one of the key reasons why securities markets have found ways to act on this basis.
Thanks, Michael. I just want to come back. Thanks for setting out the regulatory philosophy and policy. But I want to kind of come back to one important role that SGX has played in recent years, which is the duty of the directors to disclose. Now, the duty of the directors to disclose on climate matters is not that explicit in the Companies Act itself, but one can read into it the general duty. But it's really SGX that has set out, the approaches and the framework for disclosure. You mentioned TCFD and so on. So I just wanted to ask two questions. One is a more general question about what drove, was there anything in particular that drove SGX's immense focus on disclosures in recent years? That's kind of number one. And the second one is a provocative question that arose from a provocative statement I heard yesterday in Professor Megan Bowman's lecture. And I think I'll phrase her assertion, and I'm curious to hear your views. She made a statement that, so her case was that disclosure is not the solution to everything. And one particular statement she made was, myopic focus on disclosure will undermine transition. So not only is she saying that disclosure will not serve a purpose, but disclosure in certain circumstances could even be counterproductive. So I was just wondering whether you see this, and how is industry responding to disclosure requirements? Is the fact of cost of compliance a significant disincentive for companies to comply? Because ultimately, unless there's a buy-in from the companies, you can have as much disclosure requirements as you want, but you'll always be running up against a wall. So I was wondering how you think about disclosures from a regulatory perspective.
Thanks for that. I think the short answer, firstly, is that it is really the whole ecosystem that needs to act in order to bring about change. So then let me answer, I think, the specific questions on disclosures and why we are looking at disclosures so closely. Firstly, we are a securities markets regulator, and in Singapore, since 2000, we've transitioned from a merits-based regime into a disclosures-based regime as a securities market. Now, what that means is that we believe that it is impossible for a securities regulator to make decisions on individual cases or to help investors make their own investment decisions, because we do not have all the information that is necessary to make those decisions. What is a more maybe efficient and effective way to order the securities market is really a disclosure-based regime, where investors have the full extent of information that is material to investment decisions, and then they themselves take the responsibility to address these questions. Now, then linking this back to sustainability, as I've mentioned, from our perspective, sustainability risk and performance is related to business risk and performance, and consequently, investors would be interested to know about the company's sustainability performance. And that is, I think, the key reason why we've drove the disclosure regime to also expand to look at sustainability risks and opportunities. Now, if I have some time, maybe I can broadly paint the journey that Singapore has taken on this disclosure of sustainability reports. We really started in 2011 as a voluntary guideline for companies to consider sustainability and to report to investors how they're performing, what their risks are, how they're managing it, and what they're doing about it. In 2016-17, we upgraded that to a listing requirement and made it compulsory for all companies to produce sustainability reports. But we did not specify specifically what are the indicators or metrics that all companies need to report, because every company operates in a different environment, industry, and has their own idiosyncratic circumstances. So what we've said is that the board of directors should be the ones deciding on what is most material to the company and then making those disclosures. In 2021, given the global consensus on climate as the most important risk affecting businesses and the world, we made a requirement for all companies to produce sustainability report. And then we've progressed since then to move on into an international set of standards for that. But if you see this trajectory, it's really more of enabling companies and boards to provide that impetus or catalyst for them to start considering these issues, and not so much as a securities market regulator stepping in to dictate how a company should transition or what their targets should be. So our focus is on disclosure, so that the swath of investors as well as other stakeholders are able to step in to give their input to companies, and then for the companies and their directors to make those decisions for their own companies.
Thanks. So we might come back to some of this as well. So let me quickly move to Tina. So as a director on corporate boards, you have kind of a front row seat to everything that's happening in corporate boards. And you need to operationalize everything that we've seen in terms of directors' duties. So my question to you is the how of things, right? How do corporate boards, in your experience, demonstrate actually dealing with the law on directors' duties on climate risk? And how do you think about addressing the climate risk as a material financial risk? And one of the things that I would like to raise with you upfront, which if you can also address, is as a director, how do corporate boards balance these various interests? On the one hand, there's a commerciality element involved in corporate boards. On the other side, there's duty and liability and risk. So how do corporate boards exercise that balancing act in the context of climate risk? In your experience, would be interesting to hear.
I want to thank you very much for the opportunity to be here. This is the third day in a beautiful country full of growth, respect, order. I I just want to really thank you for this phenomenal opportunity to get to know your culture better. Before I answer your question, I would like to offer you some statistics to get a context about board effectiveness. And that will probably place into context a fair amount of the questions that we're going to be discussing here today. So I'm quoting PwC's board effectiveness report, and I'm quoting ACCA's report in 2023 and 2022 on banking performance, risk, and culture. 30% of boards are effective. Good or excellent? 30% of boards are effective. Good or excellent, that is. Only 34% of directors ask probing questions. %49% of directors come unprepared for board meetings. Only 63% of directors can be trusted to choose their CEO. And only 66% of boards can be trusted to lead an organization, their organization, through a crisis. And only 51% of directors are in a position to assess their own performance. So what does this data tell you? This is data, you will ask me, how relevant is this data and how accurate is this data? Well, accurate, let's park that question because I presume it is accurate coming from PwC, but how representative is this data? So we're talking about a domain of 500 boards, companies, and I would like to add to that some 400 interviews that I've done with directors, chairs, constituents, if you will, in the market in the last 3 years as a policy or applied researcher and a policy advisor. And these statistics corroborate with a lot of similar studies that have been performed by other organizations of similar statute and insights. So yes, the data is representative. In that context, it is very difficult to balance out the duty and how this duty is disposed. So this is evidence of practice. This is a beautiful curation of a panel because we have law represented, we have regulation represented. I'm really sorry that Sarah wasn't here to talk about the commercial elements of litigation. Law, as Megan Bowman beautifully said yesterday, is as good as it is applied. Unless you have stark, near precedent cases that you can lean on to summon directors' disposition to pay due attention to issues at hand, it's very difficult to progress things in a board, especially things that require sweeping change and change from what is business as usual. So in that context, disclosures can become quite secondary. I totally understand the viewpoint of regulators. We're not here to run your companies. You are here to run your companies. All we can do is force the questions. And the only way to force the questions is to look at disclosures. Interesting statistics, again, in terms of practice. And that was something that the Financial Times published 4 months ago. Of the large corporations that go bankrupt, 75% had unqualified reports from the Big Four auditors. At this juncture, we're talking about limited assurance in terms of disclosure. So how reliable is disclosure at this stage? And my punchline to all this, because I don't want to be the Black Widow of this conference, law is as good as enforced. I would love to see a share of hands here, how many cases you know of D&O insurance being tapped into. Can anyone raise a hand about D&O insurance that has been used? No, I don't see any hands. Okay. It's not about duty, it's about disposition. It's about leadership. It's about putting all these things into context and looking at the success, the medium term. Forget long term, I don't know what long term is in these very VUCA times, but medium term success of a company is something that directors can influence. Again, I'll refer to Megan Bowman's lecture yesterday because I agreed a lot with what she said. This position is about leadership. This position is about corporate culture. This position is about impact. It's not about duty. It's about impact. It's about what you bring to the table and the ammunition that you use in order to influence decisions. The starkest ammunition that you can have is fear, which comes from the imposition of the law to the extent that it is imposed, and greed, which is how much profitability you can bring. It's the old kind of primal, if you will, disposition of fear and greed that you see in corporate action and in corporate disposition at large. And really in human nature, if I may. And the bottom line here is that if you use financial materiality, whether this is climate you're talking about, whether there is any issue you're talking about, there is no way you're not getting the full attention of the non-executive and the executive board. So it is all about financial materiality at the end of the day. It's not at the end of the day, it's at the beginning of the day. And financial materiality is risk and opportunity. And in the same way that you analyze any other risk in the organization and you govern any other risk in the organization, so you should climate risk. Stress test, useful life of assets, cash flow impact, mitigating actions, cost of insurance, which has skyrocketed. These are, you ask the question, where does the rubber hit the road, Tina? Well, that's where the rubber hits the road. And that's the most powerful way you can influence a decision in the board, in the executive committee, and all the way down the chain. Now, I'll leave you with a final statistics, and I promise not to inflate your headache with these things, but according to SCCA reports, most risk mitigation actions do not cascade in an organization. So unless you have leadership that is defined by followership, not by status, there is no way you can really direct an organization. So the only way really an organization can be effective is when you see a director come to conferences not to talk the corporate speech, but to talk essence. When you see directors at the cafeteria of your offices, when you see directors walk the room, when you see directors speaking to the internal auditor and understanding what's really happening, when you see directors speak 2-3 lines below the top brass of the organization, and understand the tone in the middle and the tone at the bottom. So I've departed significantly from the opening question in order to demonstrate that it cannot be about the duty, because I have a million ways to evade the duty. Avoid, evade, and not get caught. It is the disposition, the leadership, and my God, regulators and investors have phenomenal punchline questions to ask to understand where the rubber hits the road. What is your CapEx that goes into climate transition? This is a number you cannot mess around with. It closes you in for at least 3 years in the fast-running cycle organizations. It can close you to 30 years or 50 years for the organizations that have a much longer gestation period and much longer term obligations and contracts. And I'll stop here.
Sure. Thanks, Tina. So that's very interesting to see the inside view of how boards look at climate risk. I have 2 or 3 follow-up questions to probe on this a little bit further. My first question to you, you mentioned risk and opportunity. So my own opening remarks started with, we have taken as a given for this panel that climate is a material financial risk. So we talk about directors' duties in the context of risk, but one thing we rarely talk about is what that you highlighted today is opportunity. So climate transition could also be an opportunity. So is there a way by which we can reframe the question, not to keep solely focusing on risk, but also to think about opportunity as well? And how would you look at that from a board perspective?
It's always opportunity and risk. It's always risk-reward. The one is never divorced from the other. I think to divorce the one from the other is something that is an effect of the post-2008 financial crisis, where regulators have focused on a lot of risk, and understandably so, because we were in a blow-up situation. To the extent that now you see a lot of organizations spend consciously money on compliance dressing. They call it tick box, they come in lots of different frames. But fundamentally speaking, when you see that risk management systems don't necessarily cascade in the organization, when you see compliance motivation as the fundamental risk and abidance with the regulation as the fundamental risk budget, you need to worry about it. Because risk is not the same to every organization or the same industry. But to please a regulator, instead of having a real conversation with a regulator and developing what we call regulatory equity, that, again, is a matter of disposition, not a matter of duty.
Thanks.
So never risk and opportunity are divorced. It's always a risk-reward. And just to give you another case in point, Singapore is a major shipping hub. Recently, in one of my advisory capacities, I started probing that industry to understand how can you talk about ESG not in terms of CSR or in terms of really getting a ticket to heaven, wherever heaven is. And we started doing an analysis of useful asset life elongation of a ship, commercial life of a ship, as a result of retrofit, and insurance premia going down as a result of retrofit. There is a real commercial opportunity there. And if you get into jurisdictions where you have carbon credits and carbon charges, like the European Union one, then you really see a financial commercial opportunity in very hard to abate industries like shipping. What if your directors probed a question like this in other hard to abate sectors? That is good disposition. That is good leadership. That is good discharging of fiduciary responsibilities.
Thanks. And one of the important tones of your initial remarks were directors are not driven so much by what's on the statute books and liability and so on, but it's a lot more internal leadership and other factors come into play. So I just want to ask a couple of questions. On your aspect that you mentioned about liability, I think that seems consistent with a lot of legal studies, which also suggests that the instances where directors have actually been made liable for breaches of directors' duties and have had to pay out of pocket, or even, as you suggest, let alone D&O liability, are very, very minimal. So we have all these duties in the books, but where directors have actually had to be held liable, those cases are very, very minimal, if at all. And in the climate arena, we are yet to see a case where there have been instances where attempts have been made, but it's not actually happened. But I just had two follow-up considerations. So if liability is not a significant consideration, is reputation a significant consideration? So there have been studies, including by the Grantham Institute, which I've looked at, which seem to suggest that sometimes even when cases are filed against companies, even though they have not been successful, it could have potential negative consequences on the stock market price and so on. So does the fact of a litigation affect the boards, how they look at it, let alone whether they are liable or not? That's kind of one thing. Do directors care about the reputational risk? That's number one. And the second thing is, directors' duties is not only something that can be subject to enforcement by legal actions. It is also, we're going to have a third panel today that talks about investor issues. So are investors putting pressure? Are investors engaging more on legal issues, on director duty issues? And we've seen this in the US, for example, with the ExxonMobil case, where engine number one, they managed to secure 3. That may be an exceptional circumstance. We're not going to see engine number ones around the world. But there have been instances where boards have been changed by investors. So if legal liability is not that big a consideration, is reputation, investor pressure something that boards have to take into account for climate issues?
So I'd love to, excellent question. I'd love someone to do some research on companies that have been held liable and directors getting off their boards, what fate they have in other boards. Have them been pushed out of other boards as a result of company going bankrupt? There is no blacklist for directors. There are so many asymmetries of information happening at so many different levels that can you enforce a blacklist on directors? Reputation matters. There are studies that demonstrate that if the company is in the public eye as a result of climate mishaps or neglect, then that affects the stock price. Only then do you see companies react, rather than because of their intrinsic risks. But again, how long does that last? Especially in what is now a world where you have 2 hot wars in my part of the world, and at least another few cold wars brewing that shift the attention to other different parts of corporate activity, security, supply chain, robustness, et cetera, et cetera. Now, investors have started to up the ante on voting down directors. They have. I welcome that very much, because what does that do? It gets disposition into shape. But this being a law conference, I have two questions to ask you rather than to answer, which is a bit unconventional, but here we go. Recently, we did a study with the Center for Climate Engagement at Hughes Hall, Cambridge, on corporate culture and how it is acutely financial material. I'd love to share that with you. Initially, it's directed at banks because they are heavily regulated, and you can see trends forming in that arena, in that industry. And you see data mainly from Europe, the European area, the greater European area. The principles, however, apply across industries. And I would very much welcome your thoughts on this. When you get someone to audit your accounts, you insist that that accountant is accredited. Why do you not insist that your board directors are accredited? Question number one. So you place so much onus on director duty. How do you ensure that these directors are fit and proper unless they have a proper director accreditation? 3 questions, actually. Second question, is there consensus in the organization about what the role of the board is and what governance means? Third question, seeing the many crises that we've seen, fines, banks going bankrupt, only in the last 4 years, what was the role of board evaluation where regulators and investors place such a great emphasis? And does it make sense for board evaluators not to be accredited or regulated? So I'm giving you some homework. Thank you.
Thanks so much, yeah. Michael?
Yeah, if I may maybe add some local context to, I guess, the situation that you've mentioned. I think, at least for companies listed on SGX, governance and board responsibility is one of the key factors that we look at to ensure that they've overseen the management of ESG issues within the companies. I think the disclosure bit actually prompted these discussions within the companies. So anecdotally, while speaking to some of the sustainability practitioners within companies, they've said that because it is now a requirement for there to be a board statement for the company to produce a sustainability report, that their board of directors are now asking questions and then also devoting some resource to those teams in order to run the sustainability projects within the company. So I think what at least the situation in Singapore is that the boards are now aware of ESG issues, and the question really is then what is the impetus for them to take action? Definitely, I think regulation is insufficient as a tool. It's really then the rest of the business opportunities. Also anecdotally, I think we've heard from companies and seen examples of companies that have transitioned to new areas, new business opportunities. So if I can just raise 2 examples. One is an energy company in Singapore that was traditionally in a fossil fuel industry. They've now divested these assets and then acquired new renewable energy projects in order to support their climate transition. Another is an offshore marine company that traditionally supplies the oil rigs by pulling these oil rigs into the open seas. Now they've transitioned as well to provide these services for solar panels that are placed in the open seas. I think we see then that there are opportunities that some companies can tap on, which then allows them to transition. And I think that is the probably best impetus for change when they do see a business imperative.
Thanks so much.
Can I add?
Yes.
I will corroborate what you said. In one of the boards that I sit, I sit, 6 years ago, the stock price was €9. Today, we're at €35. A significant as a result of significant deliberations in the board, we changed the strategy. And this is a utilities and metals producing board. And a big chunk of that premium, that appreciation, comes from that green strategy that is global. It operates in at least 30 countries, and it's real, hardcore evidence that there is great opportunity in sustainability transition. But again, it's down to mindset. It's down to a sense of ownership, and it's down to disposition and leadership. It cannot be duty, unless we see plenty of precedent cases that will get people very, very nervous.
Thanks. So maybe we've had a lot of discussions on many issues. Let me just change the format of a little bit before we open up to questions. So now we have a bit of a rapid fire round where I will ask a question and leave it to each of you to answer in about 30 seconds. I know rapid fire rounds are not a great thing in legal discussions because there are so many, it's not capable of one answer, but I think we can try to address a few questions if possible. So the first question is do you think there is or should be a duty on directors of companies to set a net zero target within a specified time frame?
Rapid fire. So the answer is yes, and I think a large number of corporations are, virtually competing with each other to set it. Once it's out there and a corporation makes a public declaration, then there are internal pressures which build within the corporation to try and attain that. So a large number, at least in India, have set, but it's sort of 2030, 2035. Those are the kinds of years which we are looking at. So I don't see, it's aspirational, but it's good. It gets everyone else competing as well.
Michael?
Wow. I guess I'm not as optimistic. I think the situations in different companies and industries really differ. And to set a broad brush requirement without regard to their situation might not achieve the best outcome. I would say that we would still probably, or we still should rely on the whole ecosystem in order to drive these changes.
I will be controversial. I think the answer is no. I don't want to see 2050. I want to see 2030. I want to see a 5-year plan to 2030. Because God knows what's going to happen by 2050. So no.
Yeah. Okay. So
that's
maybe
a short answer.
Yeah, thanks. So we'll come back this way. So a linked question, I think what arises from this discussion is, and this came up in the Client Earth Shell litigation as well. What is the application of the business judgment rule? So is it better for courts to leave the actual decision making to the boards? Or is it better that there's some kind of an oversight by a regulator board on this issue of either going net zero or the means of going net zero? So what is your view on business judgment and the context of directors' duties? We'll come back this way.
You saw the statistics. So what business judgment are we talking about here? I think it's important that you have an ecosystem here where business judgment is enforced through intense engagement with investors, intense engagement with regulators, and I'll say that in front of a regulator. The regulatory reports that companies receive are fascinating, extremely insightful. The amount of information that regulators have is vast. It's not their job to run the companies, but my goodness, do they have phenomenal insights into the companies that they regulate. So courts are last resort in this. And you tell me again cases where the business judgment rule ruled out a director from their duties.
I think to a certain extent, the business judgment rule is probably aligned to the disclosure-based regime that we have, where investors, shareholders are the one holding companies accountable. And I would say again that I'm not sure that regulators are the best person to make commercial judgments on where a company or what a company should be doing.
Okay, let me just share with you something which struck me. The first administrator of the US Environment Protection Agency, if I'm not mistaken, was William Rucklehorse. And I remember reading an interview of his. And, you know, he was there in the 1970s, and he was asked at the end of his term that what was your greatest achievement, or what were your, you know, big milestone achievements? And there's a lot which had happened. National Environmental Protection Act had come in. There were cleanups in Los Angeles and elsewhere, etc. And of all the points in terms of his attainment, the one he chose was a tweak in the US regulations which required the reporting to be signed by the chief executive officer. And he said that that one requirement, which, you know, it wasn't just a report, but it had to be affirmed by the top person in the company, ensured, according to him and in his assessment, that down the line within the company, there were compliances and there were accurate statements, because otherwise, if there was a departure or a deviation, it was that CEO's reputation and his liability to meet for an incorrect statement. So since we're in this regime at the present moment, which requires declarations, at least as of now, and I find at least in the India context it's not there, perhaps one way of improving enforcement without courts, increasing accountability in the board, is to pin it on the highest person within the corporate structure.
Yeah, thanks. So that kind of leads me to my final question, which is linked to what Shyam mentioned, which is the risk of greenwashing, right? You can make disclosures, you can pin responsibility on like the CEO, but how do we see this risk of greenwashing, you know, kind of coloring the whole approach towards addressing climate risk, and how do boards set up, or boards and audit committees set up practices and procedures for mitigating against the risk of greenwashing? Maybe we'll start with Tina and come back this way.
Just one point back to this. The CEO is a member of the board, is an executive member of the board. So when a board signs the accounts, if everyone's signature is on it. So I wish that the board, that the CEO would be that one bullet that can actually shift. But everyone is signing. The stats are still there. I'm digressing. Greenwashing is nothing short of classic misrepresentation. So in these reports, the CSRD reports and all the other climate transition reports that companies produce, audit committees, internal audit, risk committees have the primary role to ensure that there are processes in place that do not allow for greenwashing to happen. The only way that you can do that is to make sure as a director that to the extent that climate is financially material for the organization, you completely integrate it into your CapEx, into your operational cycles, into your supply chains, in an effective manner, not because the law says, but because it is for the medium-term success of your organization. Because you're going to find that risk in the form of a flood, in the form of higher insurance if flood doesn't happen, or fire doesn't happen, in the form of any shape like that, or consumer complaint, et cetera, et cetera, et cetera. Now, the problem with, and you said 30 seconds, right? The problem with misrepresentation here is that it really fires up in B2C organizations, not necessarily in B2B organizations. That is a problem.
Maybe just carrying on that line of discussion. I think in a recent survey by the Competition and Consumer Commission in Singapore, they found that about 50% of online product claims that things are environmentally friendly or environmental claims are misleading or incorrect. But I think the solution for now really is greater awareness of what do we mean by greenwashing, that there is a greater awareness that when you make generic environmental claims, such as something being green, being carbon neutral, that you need to back it up and substantiate it with data, with a really study on the life cycle of products before you make these claims. So awareness within the companies that these are generic environmental claims that are susceptible to greenwashing allegations. I think that's really the first step, and then doing the hard work of making those analysis on whether the products are indeed more sustainable or emits less carbon than others.
Yeah, as I mentioned, we have these new guidelines in India as of 15th of October. They're issued by the Consumer Protection Agency, both positive, you've got to justify your claims and have material for them, and there's a negative element. If you make a false claim, then you're liable to recompense. The Consumer Protection Act in India also has a class action provision. So I think if you see the past penalties or the past amounts which were required to be paid for false advertising generally or misleading advertising, they're very nominal. They don't really hurt. But with these new guidelines and definitions in the specific to the context of greenwashing, I see a potential of consumer groups filing class actions, and people will and corporations will become much more careful, because there in a class action the liabilities are likely to be much, much higher.
Thanks. So we've got a lot of food for thought in this session. So now I think we'll turn it over to the audience for questions.